In the previous clip, I focused on preparation, so how to prepare for oral pleadings. In this clip, I will provide you with tips on how to structure your pleadings and how to successfully deliver your pleadings. The pleadings consist of three parts. You have the introduction, the argumentation, and then you have the conclusion. So I will look at each of those three parts in turn. And then I will finish with some tips about attitude and how to deal with questions from the court. The beginning of your pleadings is always more or less the same, and it goes something like this.
Good morning, Madam President, Your Excellencies. May it please the Court. My name is Laura Hilt, and together with my co-agent Anna Miller, I have the honour to appear for the State of Orach, the applicant in today's proceedings. I will speak for 23 minutes, my co-agent will speak for 20 minutes, and we reserve 2 minutes for rebuttal. Your Excellencies, the issue at stake today is about the Caliph yak. The yak has populated the Gore Highlands for over 250,000 years. It's of fundamental importance to the people of Orach, who've lived in equilibrium with the yak for all this time. Now, this millennia-old species is being threatened by the production of galvectra, leading to the rapid decline and endangering the extinction of the species. In light of this development, I will be submitting 2 points. First, Rakab is responsible for the wrongful acts committed by daughter because daughter's actions are attributable to Rakab. My second submission will then demonstrate that Rakab's yak harvesting violates its obligations relating to the protection of the environment. My co-agent will then submit that Rakab's yak harvesting also violates the Arakan people's cultural and religious rights, and that Rakab must pay Orach a portion of the profits made from galvectra.
The first minute of your pleadings is absolutely crucial. You need to persuade the court of your own personal credibility. And so why should the judges listen to you, of all people? And you should persuade them that the dispute really matters to you. Try to come up with a dynamic opening to immediately grab the attention of the court. You can appeal to the emotions of the judges, for example, by explaining the relevance of the dispute to real people. So it's not just a legal puzzle that needs to be solved, but there are real interests at stake here. If the structure of your pleadings allows it, then begin immediately with your strongest argument. You close your introduction by giving a short outline of your line of argumentation. It's important in the introduction to already label your arguments and introduce those labels in the introduction. For example, you could have a self-defense argument followed by a humanitarian intervention argument, and so on. Later, when you develop your actual argumentation in the middle part of your pleadings, you can remind the court of those labels before you begin to develop that particular argument. This way, the structure of your argumentation is clear and the judges will know exactly what they can expect throughout your pleadings. So after the introduction, you get to your argumentation. And here, structure is crucial. So when it comes to oral pleadings, 3 is the magic number. So try to identify the 3 most important arguments, label them, and structure your pleadings around them. The 3 arguments could complement each other, or they could be in the alternative. Express your ideas in straightforward and simple language. Don't try to impress the court with pretentious or technical expressions or jargon, or by dumping a whole long list of case law on the court. That will only annoy them because they will not be familiar with most of the obscure cases that you cite to them. In short, keep it simple. The aim of your argumentation is to convince the court why you are right and why your opponent is wrong. Why your point of view is the better one, the one that should be preferred by the court. You do this by applying the most authoritative and relevant sources of international law to the facts in such a way that they support your position. Don't give a theoretical or academic lecture, but assist the judges in reaching an informed decision. And maybe the most important, pretend to be objective, but at the same time, the state you are representing is always right, and the other party is always wrong. After you finish your argumentation, it's time to conclude. And People remember best what they hear last, so you need to end with a strong statement and a call to action for the court. In your conclusion, you begin by briefly summarizing the arguments that you have put forward using the labels, the self-defense label, the humanitarian label, intervention label, and so on. Don't spend too much time on this, only use a maximum of 1 or 2 sentences to summarize your pleadings. Emphasize the points in your argumentation that came across as most convincing during the pleadings. So that means you need to look at the court's reaction when you develop your argumentation to see which arguments impress them the most. And remind the court of the main weaknesses in your opponent's arguments. So to do this, you need to keep an eye on the judges when your opponents are pleading and see which of your opponent's arguments were least convincing to the court. If they look puzzled or unpersuaded, then you can attack. You must tell the court exactly what you are asking it to do, and you must reassure the court and the judges that they actually have the competence to do what you're asking them to do. So that means you need to explain why the court can be reassured that they have jurisdiction and why the claim you're presenting to them is admissible. Of course, if you are pleading on behalf of the respondent, you have to do the exact opposite. You persuade the court that the ruling you are asking for is not only the one that is best supported by the source of international law that you present to them, and the best solution to resolve this particular dispute, but also that it is the most just solution for all similar cases that are to follow in the future. In other words, you ask the court to set a powerful precedent, to use the present proceedings to set a precedent. At the very end, you must remind the court once again of the larger importance of the dispute that is before them. Try to persuade the judges that the decision they are about to make will have major consequences for society, but also for the development of international law. How to deal with questions from the court. The judges will constantly interrupt your pleadings with questions. And if the judge's question can be answered by a clear yes or no, then you must do so immediately before you provide your reasons. Never say, well, it depends, or it's complicated in response to a judge's question. You always need to welcome questions, so embrace them, welcome them with a smile. And don't look annoyed when a judge is asking you a question. You need to listen carefully and be seen to listen carefully to the court. This means that you must look the judge in the eye and make eye contact, nod to indicate understanding, take notes, and if necessary, ask for further clarification. You should never ask the judge to repeat the question. That will only annoy her. You always need to answer the question immediately and never postpone or refer answering the question to some later stage by saying, I will get to that in a minute, or even worse, by referring the question to your co-agent or to the surrebuttal or rebuttal. Never praise a question. Don't say, thank you for the question, or that's a very good question. The court can only ask excellent questions, so you don't need to tell them. Willingly answer hypotheticals if the judge invites you to do so. You cannot refuse to entertain a hypothetical by saying this is of no relevance to the present case. After addressing the question, try to transition smoothly back into your oral pleading. So you pick up your argumentation where you left off. Then some tips about attitude. Don't appear overconfident. Overconfident or even aggressive pleading style will either make judges turn silent if they're intimidated by you, or it will invite them to ask lots of questions to show you who is the boss. So that in the end you're not pleading anymore, but you're simply trying to survive this interrogation. To avoid this, you must always be respectful to the court and to your opponent. Things to avoid at all times are reading from your notes, pointing your finger at the court, clicking your pen, or leaning on the lectern as if you're drinking a pint at your local bar. Other common mistakes are looking disinterested, playing with your hair, moving from one foot to the other, and so on.
Don't be nervous. Obviously, this is easier said than done. But if you remember a couple things, it'll help you relax. One is that you're the expert on your case. You know it better. You know both the facts and the law better than the judges. The other is that this is a conversation. You're supposed to help the judges learn the case better by answering their questions, not argue with them. Remember these things and have fun, and you'll do great.
That is all. I wish you good luck in your next moot court competition. All rise!